Hola, ya, ahora sí. El próximo panel será...
Next panel is going to be about IP regulation in sport betting, trademarks, data feed, and responsible advertising. The video, please.
Yo creo que ellos recién...
Regulación de IP en apuestas deportivas.
IP regulation in sport betting, trademark, data feeds, and responsible advertising. Colton partnered at ArentFox Schiff, USA. Fernanda Magalhaes, member of CONAR, Brazilian National Advertising Self-Regulation Council, Brazil. Moderator Juan Fremiort Ortiz, Peroni, Sosa, Tellechea, Burt, and Narvaja, Paraguay. Hello.
I know that we're in a rush, but it's okay. We believe that we have a terrific panel today, and we have two outstanding speakers. For an IP perspective, the discussion is especially important. We are no longer dealing only with registrations, protections, and of betting brands. Today we must also consider how those brands are used, and if the operator is duly licensed, and how sponsorships are naming right structured, how official sports data and lip feeds are exploited, and how advertising message reach customers, influencers, and affiliates. We are very fortunate to have with us two outstanding speakers. First, Glenn Colton. I guess he is already online. Thank you, Glenn. He is partner of ArentFox Schiff in New York. Glenn's practice focuses on white-collar crime, criminal defense, complex civil litigation, government and internal investigation, and sports law. He has a significant experience advising sports teams and companies in the fantasy sports and gambling industries on regulatory, compliance, and intellectual property matters. He also fully successfully represented the Fantasy Sport Trades Association in landmark litigation concerning of the use of player names in fantasy sports contests. And for that work, he was inducted into the Fantasy Sport Trades Association Hall of Fame. Great. We also have Fernanda. She has a long experience in the field. She is a highly recognized professional in marketing, entertainment law, advertising regulation, and intellectual property. She has an extensive experience advising clients on advertising, digital content, influencers, entertainment, brands, and emerging technologies. She's also a member of CONAR's Ethics Committee and served as Chief IP Counsel for Rio 2016 Olympic and Paralympic Games. Glenn and Fernanda, we do appreciate joining us together for sharing your experience and with ASIPI. Glenn,
thank you.
We are ready whenever you want, and I'm going to move the slide as you wish. The floor is yours.
Okay. Thank you so much, and thank you for the very kind introduction. Can you hear me?
Yes.
Well, very well.
Terrific. So I can't see the slides on my end, but I'm hoping to be on the slide that starts with the various forms of gaming are not the same. Hopefully that's where we are. But first, let me thank ASIPI and Juan for that very lovely introduction, and for the honor of actually sitting on this panel with someone of Juan and Fernanda's status. If we could go back to slide number 2.
Yeah. There you go.
But before, all right, so this is who I am. Folks, if anyone has questions, I remember being before you about 7 years ago. It was easy. We could just walk down the hall or grab a cup of coffee, since I'm not present in person, please take down my contact information. If anyone has questions, please do reach out. I'd be happy to answer them, to make your acquaintance. There's sometimes questions that you don't want to ask in public, and that makes perfect sense. So before I get into the various forms of gaming, let me give you a few numbers, which I was very lucky to have the assistance of one of our summer interns, Emma Tanner, who dug this out for me, so I thank her. Fantasy sports, approximately 70 million people in America play fantasy sports. It is a multi-billion-dollar industry. The sports books and the sports betting, in 2025, over $160 billion was wagered legally, and an estimated another $80 billion was wagered illegally. And then when you get to the prediction markets, on just one prediction market alone, Kalshi, in the US alone, $33 billion was placed on event contracts just in the first quarter of 2026. That'll tell you why this is so important and why there is so much focus on the different forms of gaming. So let's talk about what the three main forms of gaming are. Fantasy sports, and let's go back one, please. Fantasy sports is you put money down in a league against 10, 12, 14, 16 other people, or sometimes many more than that. And you assemble players from real-world teams in real-world contests, and you make your own, quote, fantasy team, and you attempt to get more statistics and more points than the other people in your contest. And it depends on how good you are at predicting which players will have a good day, a good week, a good season. Traditional sports betting is very different. You're simply trying to decide on one given day, typically, or one given game, which team will win or lose, which player will score a certain number of points or not, and you are betting, if you will, against a house or a entity. Either you win or lose, and the company pays you. So it's you against the company in traditional sports betting. Traditional fantasy sports is different. It's you against the other competitor. And the prediction markets are different altogether. While it may seem, okay, in the Super Bowl, I pick the Seahawks to beat the Patriots, and if I'm right, the sports betting company pays me, and if I'm wrong, they keep my money. In the prediction markets, I can buy an event contract that says the Seahawks are going to win, and it is got a value. And there's somebody in the marketplace who has the other side of that. So if I win, I get my money, but it's because somebody else invested money that they lost in the prediction market. So it's you against somebody else, not you against the, quote, house. So those are the differences between the three main forms of gaming that exist for people to, some would say, enjoy sports, some would say risk their funds and have difficulty in society for the risks that come with getting too involved in gaming or gambling. So let's go to the next slide, please. Let's talk a little bit about the U.S. legal landscape, how we got here, where we are, and maybe where we're going. Federal law is dominated by certain, frankly, somewhat antiquated and confusing statutes. The Wire Act, the Unlawful Internet Gambling Enforcement Act, or UWEJA as we call it, the Professional and Amateur Sports Protection Act, or PASPA, which, as you can see, the Supreme Court of the United States declared unconstitutional. And then a whole bunch of governments, federal and state, asserting primacy over the prediction markets and gambling. And all of those issues are winding their way through the courts without, right now, a specific outcome. Next slide. The Federal Wire Act of 1961 is the primary federal U.S. law on sports betting. And what it does is it does not make gambling legal or illegal per se. It says that the interstate transmission of sports betting transactions and information, with exceptions for transfer of information between states where it is legal, is illegal. If that sounds confusing, it's because it is. And the design of this statute was not to say, here's the federal law in all of the United States about gambling. It was simply designed to try to impose penalties on organized crime that had the control of gambling back some 65 years ago. If you're confused, it means you're smart, because it is confusing. But again, the Federal Wire Act does not make gambling illegal. It makes the transmission of information about gambling illegal. Next slide, please. The most recent federal law to be passed is the Unlawful Internet Gambling Enforcement Act, or UEJA, of 2006, a statute that was not thought out in detail. It was actually an amendment to the Safe Port Act of 2006. And if you're wondering, what do safe ports have to do with gambling enforcement? Join the club, because I am wondering the same thing as well. What does UIGEA or UEJA do? It prohibits operators from accepting bets or wagers and requires payment processors to implement policies and procedures to restrict unlawful gambling, which of course begs the question, how does the federal government define unlawful gambling? It doesn't. Whether gambling is unlawful under the UEJA statute depends largely on whether gambling is illegal under the laws of the state or foreign jurisdiction where the bet or wager is initiated or received. The federal government in the United States, under the U.S. Constitution, could exercise power under the Supremacy Clause of our Constitution to say that gambling is an interstate commerce, the federal government is supreme, and we can pass one statute to govern gambling in all 50 states. The federal government in Congress has failed to do so and continues not to do so. The one other aspect of the UIGEA or UEJA is that fantasy sports contests are expressly excluded from the definition of bet or wager if certain safe harbor conditions are met. This was a huge moment in U.S. law because now it made clear under federal law, if you meet certain circumstances and certain conditions, then fantasy sports are not illegal, they're not illegal gambling, and they are not regulated at the federal level. Next slide, please. As if the last two laws weren't confusing enough, PASPA was even more confusing. PASPA was a federal law that didn't make gambling illegal. What it did is it purported to prohibit states from facilitating betting or wagering on amateur or professional sports games. That all came to a crash when the U.S. Supreme Court ruled in the now famous, or shall I say infamous, Murphy case in 2008. Basically, what the U.S. Supreme Court said was the federal government could make gambling legal or illegal, but what they can't do is tell the states what to do within their borders. The states have the right to decide whether they want to legalize sports gambling within their own borders unless Congress speaks specifically to make it illegal throughout the country. Next slide, please. So what is the practical effect of the Supreme Court decision in Murphy? Well, Murphy did not and does not mean that sports gambling is legal throughout the United States. Rather, it means that the states can legalize gambling within their borders so long as they comply with the existing laws. Many states have, in fact, made gambling legal within their borders. The result? A hodgepodge of very disparate, different rules and regulations in different states, in different jurisdictions, in different places, resulting in what Churchill reportedly called a riddle wrapped in an enigma, wrapped in a mystery inside an enigma. It is really that confusing, and every day there's some new decision or some new proposed regulation in some state around the country, and it is very, very hard to keep up with it. Indeed, I have a home in the state of Connecticut. I can go onto my computer and play and gamble and bet on a football game on a Sunday, but I cannot, on that very same site, enter a fantasy sports contest. The results have been remarkably confusing. Next slide. And the rise of the prediction markets have just made it 10 times more confusing than that. Federal legislation could, as I noted earlier, have asserted exclusive jurisdiction over all forms of sports wagering and gaming, but the federal legislation has not done so. Not in 1961 with the Wire Act, not in 92 with PASPA, not in 2006 with EE.UU, and not since then. But in the last few months, or maybe last year, the U.S. Commodities and Future Trading Commission, or CFTC, has asserted exclusive jurisdiction, according to them, over sports event contracts in the prediction markets. And they have signaled very aggressive enforcement, which is creating a battle between the states and the federal government. You would think this would be resolved in court. What are the courts saying? Well, federal judges have and continue to come to different conclusions in preliminary rulings. And my strong belief is this is going to end up in the United States Supreme Court. It would be simpler and easier for the U.S. Congress to pass legislation and make it the same nationwide, but they have not done so. I should say, before I go further, that all of my comments here today and any of my answers are my views and my views alone. They're not the views of the firm, of ASIPI, or of any of my firm's clients. A lot of us are lawyers, so you understand what I'm saying there. Let's go to the next slide. Now, here is the latest development in the prediction markets that has been fascinating. There have been scandals in different enforcement in both sports betting and the prediction markets. In sports betting, 2 Major League Baseball pitchers face federal criminal charges for working with bettors to rig proposition bets on certain pitches. In other words, they are accused of purposefully throwing a ball instead of a strike because the bettors were betting on what would happen on that pitch. Technology has allowed micro proposition betting. And these 2 pitchers, one of whom was a major star in American baseball, have been accused of rigging the game. That case has not yet been decided, but is winding its way through the courts. And in the prediction markets, U.S. federal prosecutors have charged a U.S. Army soldier with, quote, insider trading, not trading securities, but using classified non-public information regarding the operation to capture former Venezuelan President Nicolas Maduro. This person, allegedly, who knew when the raid was going to happen and when Maduro was going to be arrested, bought event contracts predicting that result, of course knowing inside information when that would happen. He now faces federal charges. And just a couple of days ago, a Google engineer in an Italian living in Switzerland, which illustrates the reach that the federal government in the United States is using, has charged a Google engineer with insider trading. This person allegedly purchased $2.7 million worth of event contracts on Polymarket, predicting who would be the most searched person on Google. Of course, the allegations are he knew the answer. He had the inside information. Allegedly, his profit was $1.2 million. He's charged with commodities fraud, wire fraud, money laundering, and faces a very substantial prison term if convicted. The lessons of these cases are that the U.S. prosecutors and enforcement agents are thinking outside the box. They are taking classic securities law insider trading concepts. Somebody knew that Company A was going to buy Company B, so they bought Company B stock, knowing it would rise, and applying them to the prediction markets And I imagine the next thing will happen is that somebody will be charged with insider trading because they knew a player was injured or a player was too sick to play in the game or something like that. These cases will be heavily litigated and they will be very, very substantially watched. Next slide, please. So what's next? As I said earlier, what's going to happen in the courts? Eventually, I believe the U.S. Supreme Court will decide the question of who gets to regulate the prediction markets and sports betting or sports event contracts. I have no prediction how that is going to turn out that I can make with any degree of certainty, but if I stuck my finger in the air, I would say the odds are the federal government will lose in the United States Supreme Court in the same way they lost in PASPA in the Murphy case. But that is far, far, far from clear. Legislation. The U.S. Congress could pass national legislation that makes the rules clear for sports wagering and prediction markets nationwide. I say could. One could be sarcastic and say, not with this government at this time. And finally, I think you're going to see even more innovation and more aggressive enforcement of insider trading as the prediction markets become more widely used, grow exponentially in size, and that people attempt to look for advantages to make easy money. With that, I'll stop. If Juan, I don't know if you have questions or you want to ask any questions, or of course, we could wait on that and go to the real star of this panel, Fernanda, whose presentation I am very much looking forward to.
Thank you.
Okay, Glenn, thank you for your for enlightening or your panel and for bringing us your experience. I'm sure we will adapt your experience and learn about that a lot. Fernanda, the floor is yours.
Thank you. Thank you, Glenn.
Thank you.
Who needs an introduction after that? Well, thank you. Well, it's my great pleasure to be here today with you. I'll certainly spare you from my portuñol, so I'll speak in English. First of all, thank you, ASIPI. Thank you, Matias Nightinger, Ricardo Fisher, Julie Gutierrez. Thank you so much. But I really wanted to emphasize and say a big thank you to the big and great, wonderful organizing committee of this event, this edition in Asunción. You've been pulling, we know ASIPI is well known for a great place for parties and fun, but the academic program is really hitting it out of the park, so thank you for inviting me. Well, Brazil has, in the space of roughly 18 months actually, built one of the most complex and perhaps consequential betting regulatory frameworks in the world. From scratch, in real time, and under huge political pressure. The betting industry took us all in the market in Brazil, took the content, entertainment, and sport market by surprise, by storm, creating, and that here comes us, creating direct consequences for how we advise clients as it relates to trademark strategy, slogan registration, talent and influencers agreement, naming rights, sponsorship agreements, and advertising compliance, so on and so forth. So my goal today is to take you through the regulatory, advertising, and IP framework and through the cases that has been helping defining the market and how we see betting regulation in Brazil. Starting with the legislative journey, I think it's quite important to emphasize the leap that we had here from 1946. And I can see very well the numbers, so I hope you can, too far for me. But until 1946, actually until 2018, from 1946 until 2018, any sort of gambling was absolutely prohibited in Brazil. Of course, we had illegal gambling, and we had many, data that illegal gambling and slot machines were used by criminals and to, make viable the crimes around that. But at least publicly and legally, that was strictly prohibited in 2018. The 1946 law is still in force, and that's why we cannot have physical casinos in Brazil. But the 2018 law opened the first door to what we see today. And growing up there in Brazil, I was very much certain my entire life that no gambling was ever allowed in any circumstance. When in 2018, I myself started to see these brands of betting platforms flush the market with advertising and sponsorship and, being everywhere in social media. And truly was a shock for me at first when I got to learn what the law has actually what had approved. And between 2018 and 2023, so in this 5-year period, even though betting was allowed, there was no regulation on how that could have been done. So we saw a flush of all sorts of practices, some very ethical and pretty good practice, and some outrageously illegal and abusive. And that's why the urgency of the 2023 law was really felt in the market, because, at least from my perspective, advising brands, advising agencies, a lot of advertising agencies, nobody really knew what was right and wrong other than the general principle of consumer protection, CONAR, the advertising board, general guidelines as to how to advertise this now new industry. Then nobody really knew how to play, nor the platforms, nor the agencies, nor the media channels. At the same time, pretty much days later after the law was passed in 2023, December 23, CONAR issued its guidelines specifically for this industry. If you know CONAR a little bit, the code, the ethical advertising code, has general principles, and then they have a number of specific annexes for industries, from food industry to pharmaceutical, over-the-counter, so on and so forth, beverage and alcoholic drinks. And the Annex X is the annex related to the advertising industry. From early 2024 on, the regulator, the Secretaria de Prêmios e Apostas, SPA, and I'll mention that a few times, has issued a number of ordinances regulating, again, the practice of the business, the betting industry, including advertising rules for the same industry. I'll go over through some of the aspects of all of this, but I wanted to highlight here the 2026 bill, which aims to ban all advertising related to betting. So I think my point here is just to say that even though I don't think there's a point in return here for the industry, politically and socially, this has been a shock for society in Brazil. And there's a lot of nuances there on how to perhaps limit. We'll see that at the end, where we are in this, I guess, cultural balance or contract with the industry. To give you some perspective, Glenn talked great about the US market. I think we're far from that perspective in terms of numbers, but this can give you a little bit of a flavor of what 2025 alone, again, the first full year of full regulation of the industry in Brazil. I had the opportunity to advise a number of, again, agencies. I never worked for any betting platform directly, but the agencies were highly concerned before 2025 of how to do the right thing, given contracts, so on and so forth. In 2025, really showed the difference of doing business under a regulation and a law versus not having much of a clue and not wanting to invest, afraid of how regulators would enforce the business. In terms of advertising, to give a perspective of what is the advertising market in Brazil, we have a 95.2 billion reais total investment in advertising, a growth of certainly growing constantly from 2024. And here you can see the categories of advertisers or brands. And the betting industry is right there in 5th or 6th place. behind traditional advertisers such as pharma or food and so on and so forth. I think it's interesting to also see specifically when we think about sports, the theme of our arena this time, the impact that it has had in sports. We are certainly not only exposed to these brands in every sort of naming rights, from the naming of the stadiums to the plates and the advertising spaces in the stadium, but certainly money behind small, middle-size, and major football, soccer, in this case, Professor Zvi mentioned football, say soccer, behind these teams to really support. And certainly that made a difference in the capacity of the teams to have, to be very competitive and invest behind the team. And I could not honor my own team, told Paulo Parente, hold off, I'll cover that for us. But Flamengo was, is the largest soccer, I'll go back here because I think I have that number. Flamengo is the largest or the number one team in terms of sponsorship from betting brands. So going to the regulatory and enforcement architecture, I think it's important to understand who does what and even what's the power of CONAR. I'll start by saying that CONAR is a self-regulatory board. It's a non-profit, not a state-run organization. I have the privilege of serving there as a volunteer, as a member of the board, so a judge of CONAR. All of the work is voluntary. They have representatives from the media industry, from advertisers, from the civil society. That's the case of myself. And they do not have any police power. But CONAR is taken as absolute the reference when it comes to advertising. And as we're going to see here, the authorities use CONAR or consult CONAR to start cases beyond the self-regulatory spectrum. So even though it doesn't have a police power or fining power, it's a very, very important element in the structure of enforcement. But in terms of hard law, the Ministry of Finance is the entity that regulates the betting industry. It has its SPA secretary or agency that regulates and is the entity that authorizes the operation of all the 30-some or 40-some betting platforms that are now operating in Brazil. And SPA not just regulates, but enforces the law and its ordinances as well, its portarias. The other element on the federal level that I think is important to note is the Senacon. Senacon is a consumer protection agency, federal agency. Yes, this one with a big police power, because its whole function is based on the consumer law of Brazil, which is a 1990 law. And obviously we all know consumers have a different way of enforcing their potential harm or risks, or damages, I should say. So it has an immense amount of power, and we're going to see some cases here where Senacon got involved to protect consumers from the betting industry, specifically from the angle of misleading advertising, abusive advertising, but it certainly has been active in the whole spectrum of enforcement. And then the Supreme Court of Brazil as well. The role of the Supreme Court started to pretty much come into play mid last year, 2025, as the numbers of this official now market started to come out. The impact culturally and financially and economically in the market was felt really deeply. We have federal bank associations suing to limit the way the betting industry or the betting platforms can use the consumer, could use money or could collect money, because we see, just like the trend of the weight loss medication, that you now see the impact all over the industry, the restaurant industry, the aviation industry, the clothing industry. This is also being hit, making a parallel here, by the betting industry. People are getting into debt big time. And so the banks are feeling the pressure, the wholesale, the fashion industry. People are not buying food anymore because they're in debt and because they're gambling in a negative way. So 2 lawsuits were filed before the Supreme Court by the National Commercial Association and by a party specifically to try to limit or void the 2023 law. And the Supreme Court acted on it, basically giving an injunction, I think it was July last year, on 2 fronts. First of all, complete ban on advertising that would target minors. The law was clear as to that, but the Supreme Court gave an order to Senacon and the SPA agency, go after anything that tries to leverage kids. So that's now, it has the power of not only the legislation, but the court decision. And the second one, ordering the finance ministry to urgently limit the way people are using social welfare. If you're Brazilian, you know Bolsa Familia, right? The welfare system from being used to apply towards betting. So if you're a recipient of Bolsa Familia or welfare, you cannot be betting in these platforms. They do the crossing based on your social security, your CPF, and then you're prevented from doing that. Because obviously if you're under welfare, you shouldn't be, that's the rationale. You shouldn't be using the money to bet on making more money. Now we're going to dive a little bit into the rules specifically in some of the CONAR cases. So I'm not going to read all the bullets here, first because I really can't. It's too far for me. But I highlighted here the most important aspects of it. From a CONAR Annex X perspective, the principles are responsible gambling. So the ads must include the language, the warning language, such as is used for the drinking, the alcohol industry, such as this could cause addiction, play responsibly, so on and so forth. I think one of the principles that are very, very important here, because it's subjective, is this idea that gambling could be conceived as something attractive. And I always think about my advertising agency clients, my brand clients, all together. How do you make somebody want to use your product if you can't tell them that is going to give you something in return, going to give you a feeling? So that is a major, major challenge for the industry, because they have to, similar to alcohol again, you have to make it attractive. You have to invite consumers to use your product, but you can't promise, financial success. You can't promise that, play and win. You can't promise, you can't go around the teens and anybody and that's a hard law. It's a rule from CONAR as well. The models that are in advertising must be 21. It must appear 21. So it's quite complex nowadays to create a campaign. And again, in my experience, that's also why the brands have preferred sponsorship agreements. And because that's easier, you just put your brand out there in T-shirts and on the stadiums, naming rights. But the advertising industry is still figuring out how to communicate betting in a responsible way and avoid CONAR consequences, Senacon, and SPA as well. Needless to say, only licensed operators can do business in Brazil since January 2025. It doesn't mean that we don't have illegal gambling, illegal platforms, I should say. We do, and we do a lot. And another topic here that I think is quite important is the liability in terms of your influencers and your affiliates. I'm glad Glenn touched on this, and I think actually was the former panel, the last panel, when we talked about what is an affiliate, what's the difference between an influencer and an affiliate. And CONAR has defined that. I'll cover that in a slide. CONA had issued a 2020 influencer guideline trying to direct the industry and the influencers on how to do advertising using influencers. This is 2020, way before the 2023 gambling law. This guideline of 2020 was really directed at this, at the time, new practice of advertising through influencers. So at that time, what we used to see at CONA from cases were hidden advertising. So an influencer that did not disclose properly that was being paid to say, this product is great, I use this in my hair and my hair now looks great. They were doing hidden advertising. So that guideline from 2020 tried to define what an influencer was and try to frame, look, you have to be transparent, you have to tell if there's any connection between you and the brand, you have to disclose and who the sponsored or whatever. CONA just issued, literally June 1st, so yesterday is now in force, but it just issued 10 days ago, a revised guideline to include more of the spectrum of the of not only the influencers of the old influencer style, but the new influencer style, including the affiliates, and trying to encompass now the idea of the betting industry as well. I think what I would highlight here are 2 points. One is, again, reinforcing that betting platform, or any brand for that matter, is strictly liable for all the content that the influencers publish. It happens almost every court day of CONA where brands say, sorry, I don't have anything to do with this. I didn't influence the content. I did not give him a script, so I can't be liable for this. Literally the day before this was published, this new guideline was published, we had a case exactly like that, and we couldn't do anything about it because it was the case was pre-publication, but now no longer that's an excuse that, hey, I didn't direct the advertising. If somebody's speaking about your brand, you are liable for what they say. So you better have your watch out service, of what people are doing with your brand. At least you can show CONA, look, I've been training my guys, my task force of influencers right there. I have a program, I have a compliance program. At least you can get yourself out of trouble by showing that you're a good brand behind these bad influencers. And then the second point is the ECA Digital. That's a law that came into force in March this year, and it doesn't have anything or specific rules as to betting, and I'll just mention here because it regulates any digital advertising involving children. And we already know that gambling advertising for children is illegal, but the ECA Digital expands the way platforms, or the regulation as to how platforms can or cannot, in this case, profile children's social media accounts or design advertising specifically for children. So that impacted, the ECA Digital impacted the whole influencers market as well, as they were doing that. They were targeting kids to use betting platforms, and perhaps not bet for sports, but certainly for attracting kids to use a number of games and video games that in the end had the mechanism of gambling, such as loot box. Loot box is that feature in video games that you bet to have a chance to win more coins, or you bet to win. So that is already a betting mechanism, and ECA Digital seek to regulate that as well, and banning the loot box practice. So as I mentioned already, the enforcement challenge here is that even though all this framework has been put together, the entire task force of regulators is in place, 80% of CONA's complaints up to this point is of unlicensed operators. So the illegal operators are winning the battle up to this point. So the solution to this has been that CONA has established a protocol with SPA to have some sort of system of consequences. So CONA monitors, it flags to SPA, which has the police powers, and it works with the ANAC and Anatel, which are the regulators in Brazil for internet and signal and I forget the word now, but that regulate the transmission of information online and so on and so forth. So they would have the power to take down these 80% unlicensed operators. I'll go through here some of the cases. I promise we don't have a lot of time to go through the details, but I just wanted to call out the language that the campaigns have used and what has caused problem. This is a 2024 case, so before a number of these, before the law was already applicable, but you can see here the taste of CONAR decision. The campaign was distributed, it's a SMS campaign to a number of cell phones nationwide using the slogan, live the emotion of playing and being part of this experience where luck awaits and winning is just the beginning. CONAR interpreted that, saying that basically winning is just where you begin in this platform is misleading to make consumers believe that winning was guaranteed, and that's again a major no-no for betting industry. This case was initiated by the Ministry of Finance. As I mentioned, they do have the prerogative of initiating a case with CONAR and letting the process go through, and with this decision they take action against the platform. This case was Blaze.com. Final ruling, as I mentioned, unanimously, CONAR recommended that the alteration of the campaign and the suspension of this kind of messaging. Another case, a little bit later in the year, 2024, November, Sports da Sorte, using the turbinate your extra income, also found problematic in terms of promising gains when we all know it's not guaranteed whatsoever. And also using this affiliate program of not influencers again, but affiliates who earn based on clicks. And that's the difference between an influencer and an affiliate. Affiliates basically have a link in their post, you click there, and then when you go to the platforms and you play there, whatever you lose or the house wins, they make a percentage of it. So it's quite complex, and the affiliate program is not something just that the betting industry uses, but that's how it works in this scenario. And I think the third, not the last, but the third case was a very, very complicated one, and this one got the advertising Tropicalize bet in trouble because they were using kids as influencers to use the platforms with cartoon language and attract children to that environment of betting on some sort of win, not necessarily cash, but more prizes and through the video game. So this is one of the series of representation at CONAR. In this case, the platform was also warned by CONAR publicly of the advertising non-compliance. Let me see if I can. Sorry, let me just go. Sorry. I'm going to play to you this one case that turned out to be this fourth case, but I'll play the video before I do, and I'm sure Brazilians will recognize that as one of the most perhaps efficient brand strategies recently.
Brasileirão betano. Brasileirão betano.
Brasileirão betano. Brasileirão betano.
Brasileirão betano. Brasileirão betano. Brasileirão betano. Brasileirão betano. Brasileirão betano. Ninguém fala em outra coisa. Brasileirão agora é Brasileirão betano.
So I like this case, one, because it's very easy to understand, right? Brasileirão betano. There's no need for translation there. Brasileirão, for whoever doesn't know about it, is the national soccer championship in Brazil. And Betano acquired the naming rights to associate itself with the championship. It just happened that CONAR understood, and I think it's important to say when this happened, March 2025, beginning of this now regulated market, where the brands are really trying to make sure that they are distinctive among themselves, considering that everybody's something bet, something this bet. So it's quite hard to say, where am I going with this? You know, which platform am I supposed to believe or trust? So they're trying to reinforce their brand, but the way they found of repeating constantly as if it was a language, so it didn't have anything, no reference to certainty of gains, but the overuse of the brand was interpreted as a constant marketing strategy to reinforce you should be betting, everything's betano, from the weather forecast to cutting your hair. You just have to be thinking about betting, the behavior of betting. So it was considered a problematic advertising, removed, betano changed to the point that they don't have the announcers on television calling, which they were before, Brasileirão Betano Championship. Now it's Brasileirão again, and they have the naming exposed everywhere, but they can't be repeating Brasileirão Betano all the time. I'm not going to run it again. So where do we get here when we talk about IP and all of this? As I mentioned, it's not just the naming rights, it's not just the sponsorship agreements. It kind of hits our core in IP here. As we talked about trademarks and slogans, these brands are quite common when it comes to the naming, at least. I myself have a hard time even remembering them. Like, which one is, I think Brasileirão Betano probably is the one that I did stick mostly, but all the other ones, I have a hard time remembering which one is Esporte Nacional, Nacional Esporte, and so on and so forth. So trademarks have become something more relevant for them since 2025. And I'll just highlight and connect the dots here that, as I'm sure you all know, first of all, the PTO in Brazil allowed, since 2025, the language for protection of these trademarks, because, as I said, until 1918, any gambling was considered illegal. So the PTO had to revise its guidelines to allow for this category of service and products eventually. But I think the important or interesting part is the slogan registration, which is also something from last year. As we saw, slogans is where the brands are now differentiating themselves and making consumers navigate, I guess, all the choices they have in terms of brands. So I have advised a number of the agencies look to have some sort of slogan that talks about betting and informs about betting and in a way incentivizes betting, but it's not illegal under CONAR's watch. As you know, this is, I think it's known information. If the slogan is a mere advertising language, it's not registrable. If it is distinctive, it could be registrable by the PTO. And I think the watch out here is just because you got a registration with the PTO for a trademark, a slogan as a trademark, doesn't mean that you're going to pass the criteria of CONAR or Senacon, that slogan is not perhaps incentivizing overuse, over betting, so on and so forth. So here's a few examples of slogans of these betting platforms. So practical takeaways. I'm not going to read them all, but for the platforms, operators, you have to know that your influencers and your affiliates are now part of your problem. It's not just the slogan that you chose or the sponsorship that you chose or the athletes, the former athletes that you chose to be your spokesperson. Your influencers and affiliate are part of your ecosystem. You're liable for what they do. Try to read there so I can recall. Children advertising is a no-go from the start. Watch the way you advertise. Make sure you're careful with the use of images and cartoon and colors and fruits, because that's going to be applying against you. And I think from a Senacon point of view, if your clients get any warning, any contact by Senacon, red flag right there, because it's fast. It's faster than courts, it's faster than CONAR, faster than SPA, and they have the power to take you down and impose major, major fines. And I put some watch outs on the bottom. I think the comment is the Supreme Court is part of this equation. As I said, it's a social, economic issue for Brazil. There are a number of bills discussing banning advertising of the industry or platforms. At the same time, parallel to that, discussion about legalizing casinos, so revoking the 1946 law. And in my view, we will have more restrictions to advertising and marketing in general for the industry. This is literally 10 days old. Lula, our current president and candidate for re-election, has said that if it was up to him, he would ban betting. The story behind that, the political story behind that, is that he's trying to get access to the women voters because they are the ones suffering the consequences of their spouses or partners over betting and going to bankrupt and having debt. And actually, I forgot to mention one of the slides. One of the aspects of the law determines that the betting platforms cannot take credit card. They can take debit card or even PIX, which is the automatic payments, but not credit card, because you cannot allow consumers to get into debt by borrowing money in credit card to pay the betting. So it's either money now or no betting, and this is part of the reason why he's so aiming as prohibiting or at least more strongly regulating the industry and communication around it. So thank you so much. This is a great opportunity for me.
Thank you, Fernanda, for your astonishing publication.
Thank you.
I'm afraid we are running out of time, so maybe someone from the audience wants to ask something. Una pregunta? I promised Ricky I will do my homework, so I did it. So if no one is going to ask, I will do my homework. For Glenn, you were talking about fantasy sports, traditional sports, betting, prediction markets. From a regulatory standpoint, what is the first legal distinction we should make when analyzing gaming products? Chance, skill, financial prediction, or traditional wagering? And then, are prediction markets the next frontier where gambling regulation and financial regulation collide?
So, to answer question number 2, yes, prediction markets are the next frontier for sure. Okay. It's very hard to sort of give a short answer to the differences, but the critical difference between fantasy sports on the one hand and prediction markets or traditional gambling on the other is fantasy sports does not really pose a risk to the integrity of the sports contest, whereas you can, bribe or extort an umpire, a referee, one single player, a coach. Fantasy sports involves grouping together people involved in 5, 10, 15 different real-world games. So the biggest difference in my mind between fantasy sports and gambling in the prediction markets is the lack of risk to integrity to the underlying sports contest.
Thank you, Glenn. For Fernanda, Brazil moved very quickly from authorization to a fully regulated market. Hopefully, one day we will do the same, hopefully. What has been the most difficult compliance challenge for operators? Licensing, advertising, influencers, or consumer protection?
I think right in the beginning, for you to be an authorized platform in Brazil, the threshold is pretty high. I think the license fee for the first 5 years or something like that, it reaches about 60 million reais. So it's not for small platforms, it's not for small players. Obviously there's a policy behind that. One is to make sure that, if people are putting money in, the house has money to pay back, but also to fund the whole framework of enforcement. This is highly expensive and highly complex. The SBA was the organization or the agency that regulated sweepstakes, so they were reviewing promotions and that kind of stuff, and all of a sudden now they're going after criminals and non-compliant license platforms. So definitely the money helps fund that. I think for 2025, from 2023 and 2024, I think that was the challenging. Getting to Brazil, complying with all the regulations, making sure that you're able to show that you are what the law requires you to be as a platform. You cannot be owned by foreign entities. So there was a lot of joint ventures. For instance, MGM Casino had a partnership with a local entity and the local entity controls that now joint venture because the platform needs to be licensed in Brazil, needs to be controlled by Brazilians, and they're liable for that platform. So it's not I guess, purely international companies entering Brazil and doing whatever they wanted in terms of market. So I think in the beginning that was the challenge. Nowadays, no question is advertising. And that's why I think this makes a lot of sense for us to be talking here, because the brands, the non-betting industry brands will definitely be talking to the betting industry brands very shortly. Co-branding and partnership and sport brands and clothing brands, they're going to be talking, because it became an industry overnight, pretty much. And that's when things in advertising gets complicated, because marketing, as we know, marketing folks are very creative. They love to be, but they don't necessarily know the industry next door. So if a sponsor of a team wants to do something with a betting sponsor, now you have to educate your client that, look, now you have a regulated industry here. You can't just say whatever you want. That's out the spectrum for you. So I think advertising is the new great challenge.
Great, because with the new CONAR regulations, I like to go more on an IP question. And can I see if a slogan be registrable before IMPA and then still be unlawful from an advertising standpoint of view?
Yeah, I think that was the watch out. I mean, you should not consider that your registered slogan, first of all, it has to be very distinctive. And in this realm of betting is hard to get to that point. So I think that's the first hurdle. But once you get the registration with the PTO, if that slogan, even on a first review basis, looks like it's not encouraging overuse of the platform, perhaps in the context of an advertising campaign, it could get to that. We had a case with, I'll just finish this one case, but we had a case when the discussion was about every day is a super day for Superbet. And CONAR thought every day is a super day, kind of implies that if you use the platform, every day you're winning, because super, how else could it be super if you're losing money? So it has to be very, very well thought out before you use slogans as your identification, if you will. If it's kind of casual, maybe it's worth the risk. But if you really want to invest in that to the point that you're going to file registration, you should really think about what you're going to do with that tagline and that slogan.
Okay.
Thank you.
Well, this is a great topic to still talk about, but unfortunately we have to lunch. Glenn and Fernanda, we do appreciate for sharing your experience,
so much.
Your knowledge, and your commitment with ASIPI. So hopefully we still have another talk about this. Just matter as soon as possible.
Thank you very much.
Si no tenemos más preguntas, podemos declarar cerrado este.
If we don't have any more questions, we close this panel. Thank you very much.